Good morning, everyone.
So what better way to start your
Jeff
day
Vastola
than by
here
getting free legal advice?
to give you free legal
This is
advice.
Vastola on the Law with your host, attorney Jeff Vastola, featuring 30 minutes of free legal advice. Call in now with your questions. 877-850-8585. That's 877-850-8585. Now here's your host, attorney Jeff Vastola.
Good morning, everybody, and thank you so much for tuning in. This is Jeff Vastola. I'm an attorney, and I'm here to give you free legal advice. I'm here every Saturday morning at 7:30 for 30 minutes. You can hear me on the radio, which you just heard the introduction, and I have to sit here like a doofus for 30 seconds while it's playing. You can call in, as the guy that does the spot just said, 877-850-8585. That's the number to call into the show. And Sharina is the board operator today. Good morning, Sharina. Hope I didn't catch you off guard. I hope you're well. She will take your phone call. Good morning. Thank you. There she is. And we've got folks chiming in from Facebook Live already. Good morning, Ricardo. Nice to see you. You going fishing today? And seas are going to be up. You can call me and ask me anything you want, preferably legal. And I will do my best to answer your question here and now. And as well, if you're watching on Facebook Live, then you can also type in a question. And if I catch it in time, then I'll do my best to answer your question right here and right now. If I don't know the answer to your question, then, and I'm my worst critic, I will tell you that, then I'll do the research I have to do and get back with you the following week with an educated response to your question. So that's how it works here on Vastola on the Law. All you have to do is come up with the questions. So feel free to, let me see, Ricardo's responding to me. All right, well, enjoy it, Ricardo. Hair conference. Ricardo is our dermatologist. But so anyway, I have an agenda just in case people don't call in or ask me questions, and just in case there's no interaction. But let me remind you, I prefer interaction. I do want your questions, whether it's over the air on the radio or by Facebook. Good morning, my sister Lee. How are you? So please, you can sit back and just watch and listen if you want, but my preference is that you call me and let's talk. What happens a lot of times, and I do offer my cell phone, I don't want to retract any of that. People call me after the radio show with topics that are perfect for radio show conversation. Oftentimes people will call me because something is of a personal nature they don't want to share, and I understand that, and I have no problem with it. But sometimes people call me and I think, well, geez, we should have talked about this on the radio show. So take me up on it. Good morning, Bill. Nice to see you on Facebook Live. So 877-850-8585 is the number to call in. Sharina will take your name. Just don't give us the names of the people that you want to sue. And mind what I say, mind your P's and Q's. My topics for today are the difference between stacking uninsured motorist coverage and non-stacking uninsured motorist coverage. If you are a frequent flyer with me, you'll know that insurance is one of my, is a topic near and dear to my heart because of how I see it affects people. And so I do my best to try to educate people on insurance, what different types of coverages there are, and why you need typically better coverage. Good morning, Mom, chiming in from Facebook Live in Tennessee. Remember, I am licensed in Florida only. My advice is only good in the state of Florida because states' laws may differ on certain topics. For example, insurance, automobile insurance. That's a perfect example. The state of Tennessee may have different laws than the state of Florida, and pardon me, I want to make sure that this is not my board operator telling me that I've been disconnected, which is what happened last week, and I ignored the phone call, and I didn't find out about it until the end of my show. But no, that's not Sharina. Looks like we're still good. Okay. So let me get back on track. My train derailed. I'll be talking about the difference between stacking and non-stacking uninsured motorist coverage, because ordinarily when I'm talking about insurance coverage, I will tell you that you have to have uninsured motorist coverage in the state of Florida. It's really super important. But if you dig a little bit deeper, you learn that there's actually two different types. There's a stacking version and there's a non-stacking version. And so the question comes up oftentimes, Jeff, should I get the stacking or should I get the non-stacking? Well, my answer is this. get the stacking if you can afford it. Okay, insurance should be based on how much can you afford. That's how you should be making your decisions, in my opinion. But understand that there are a lot of optional coverages out there, and if you're pushed to get the state required minimum, or worse, if you're told, hey, you've got full coverage because you have these two things, understand that full coverage is a misnomer in the state of Florida. You could be fully covered, quote unquote, and have an awful insurance policy. It will not protect you the way you want, and yet you're fully covered. Makes no sense to me. I don't know why people, specifically insurance agents and the independent insurance agents typically do a very good job of explaining all of this. It's the people that spent a weekend to get an insurance license and they're answering the 1-800 numbers at the big box insurance companies that, frankly, in my opinion and in my experience, are not taking the time to give very good advice about what the insurance coverages are, why you need them, what's the difference. Oftentimes, I'll talk to insurance folks, entry-level folks, and sometimes I get the impression they don't even know. So be careful. Make sure you're asking the right questions when you're getting your insurance. Whoever you choose to use is fine. I have my opinions about who's good and who's not. I'm not going to share them over the radio, of course, but if anybody has any questions and you want to ask me personal, Jeff, what should I have? Then I'm happy to answer those questions, even though I'm not an insurance agent. And I always tell people this, I don't get kickbacks from my agent or whoever I may refer you to. I just do it because you need it. It's in your best interest. So I'll be talking about those differences between stacking and non-stacking uninsured motorist coverage in the state of Florida. And then I'm going to switch gears, if I have the time. I'm going to be talking about bad faith claims against insurance companies in the state of Florida, regulated by Florida Statute 624.155. Some people have heard of bad faith, some people have not. It's a very interesting topic. It's a very difficult concept to grasp, and it's even more difficult, I think, to actually get there in real life with a bad faith claim. They happen very rarely, but we'll talk about it. So the reason why I come up with topics to discuss is because these are things that I've experienced in my work week at some given point, and I think that's a great topic for the show. And that immediately kicks me back to that Seinfeld episode where George and Jerry are sitting at the diner table and they're talking about doing a show, and George says, "That's a show. It's a show about nothing." That's my radio show. I have a radio show about nothing. So let's get into it. And remember, if you want to call into the radio show, please do. 877-850-8585. Even though I have a outline prepared and I've got my own topics that I'm ready to talk about, I give priority to people that call into the show, or if you happen to type in a question into the Facebook Live feed, then I'll give priority to that as well, because I prefer to have the interaction. So there you have it. I do want you to call in. So if you're in Florida and you're reviewing your policy and you're saying to yourself, well, geez, I don't have UM coverage on my policy, or even if you do, and you're saying, do I have the right kind of uninsured motorist on my policy, or maybe I should get more, look at your declarations page, sometimes referred to as a deck page, and look to see first if you have UM coverage. And if you don't, Monday morning, or perhaps even today, if you call an 800 number, get it, because it's that important. You're going to have bodily injury on your policy to get the UM, but make sure that you get it. And so then the next question is, okay, well, geez, there's all different amounts. Well, what should I get? That's where your finances should dictate what you should get. Uncle Mike, how are you? Nice to see you. So then the next question may come up. All right, well, now I see that there's an option to stack UM coverage, or perhaps not stack UM coverage. Hey, Lindsay, Sister Lindsay. So oftentimes the insurance agents will tell you, if you have multiple vehicles on a policy, that you should stack the policy, because in its simplest form, stacking UM insurance coverage can be multiplied, the benefit amount can be multiplied by the number of vehicles that you have on the policy. So that in and of itself is enough justification to opt for the stacking insurance policy. Now, there are times when you don't have more than one vehicle in the household, and it still might be a good idea to get the stacking coverage. But let me explain how you can multiply the benefits using a stacking uninsured motorist coverage with multiple vehicles in the policy. So keep in mind, if you're asking yourself, what's uninsured motorist and why do I need it? Well, it's the kind of coverage that's going to protect you, your family, anybody else in your car. If somebody causes an accident and injures you and causes you to have all kinds of medical bills, or you can't work anymore so you're not earning your income, any kind of physical loss, but in the form of an injury, or any kind of a monetary loss, is going to be covered by coverage. And in the state of Florida, this is the most important thing to get from this show. Understand that state of Florida required coverages do not require the other driver that hurt you to carry the kind of coverage that's going to pay you anything. That's the problem. That's why most people think, oh, I'm fully covered, I'm okay. No, you're not, because the state required minimums don't do that for you. So you have to cover yourself. Good morning, Jeanette. Nice to see you as well. So that's what uninsured motorist is for. It's to protect you and your family, anybody in your car, financially. It can also protect you from financial disaster. Keep that in mind. If you have 3 vehicles in your household and you say to yourself, well, you know, Jeff, financially, we really just can't afford to get the $100,000 coverage. We could really only allocate enough for the $50,000 coverage. Well, with 3 vehicles on the policy, you can multiply that $50,000 benefit times 3, and you'll actually have $150,000 of coverage because of the stacking option. Now, that's not the only thing that stacking does, but it literally will stack the vehicles and stack the coverage. So 50,000 can equate to 150,000 if there's an accident and you need to utilize those benefits. So that's, I think, the most basic understanding of what stacking does. But if you dig a little bit deeper, and oftentimes you'll see policies written for stacking coverage when in fact there's only one vehicle, that doesn't necessarily mean that you've been sold a worthless premium. You can stack coverage for other reasons, and that's one of the things I wanted to talk about, because of course you can opt for non-stacking coverage. Now keep in mind, if you've got 3 vehicles on your policy and you opt for the non-stacking version of you're only going to get the $50,000 in benefit. You're not going to be able to multiply that by 3 because there's 3 vehicles on the policy. And keep in mind, there's a company out there who writes an individual policy for each vehicle in your household. In the event that you're with that company, if you have multiple policies because you've got multiple vehicles in your household, just make certain, if you want these benefits, that you're getting the stacking coverages and you're getting the coverages on these vehicles. I still don't really have a good explanation from the company as to why they do it that way, other than this is the way we do it. Believe me, I ask. Every time I get an opportunity to ask an adjuster with this company, why do you do it that way? The answer is, that's just the way we do it. Which, it's kind of a frustrating answer. Good morning, Dad. Nice to see you. So, here are some of the differences between stacking and non-stacking so that you can make a decision as to which one you want. I would recommend getting the stacking version. So, of course, if is rejected, then you're not going to have it anywhere. And in the state of Florida, the insurance company is obligated to kick out a form with your signature on it, says, I reject all forms of coverage. Now, nowadays, most of the forms I see are electronically signed, electronically generated, and I start to wonder to myself, did this person even see this form, or did they read it? Did they understand it? Was it explained? I think most times the answer is probably no, but that's why I'm here. If you have any questions about the coverage, then you can certainly ask me anything you want. And let me kick out that radio number real quick. 877-850-8585. That's the number to call me here. That will get you into the radio show. And Sharina will put you live here on the program with me. And we'll go from there. But so if you're injured and you're in a vehicle that you own and it's on the policy, then either stacking or stacking is going to provide the stated benefits in the policy. Just keep in mind, if what I talked about before. If you have more than one vehicle, the stacking version is a better option. It's going to give you twice, 3 times, 4 times as much coverage. You'd be surprised how many times people come to me with multi-vehicle policies. They've opted for coverage, but they've opted for the non-stacking version. And I say to them, look, you've got $100,000, you've got 4 vehicles on the policy, but you've limited yourself to $100,000. If somebody should really cause an accident and injure you, you could have had it as much as $400,000 of coverage. Why did you not elect stacking coverage? It was going to be like $25 more. And honestly, the response is, we had no idea. Obviously, we would have paid the extra money to get the additional coverage, an extra $300,000 of coverage for pennies, and people don't do it. And so you wonder why, I'm so emotional about this topic. Good morning, Patty. Nice to see you. Hope things are well. So the obvious, if it's on the policy, then you get the benefit, right? No big deal. Now here's one. If you're injured in a car that you own, but you insure that vehicle outside the state of Florida, snowbirds, listen up. You might have a vehicle up in the Northeast, and you might also have a vehicle down here in the state of Florida. You might have a Florida insurance policy here, and you might have a New Jersey policy or New York policy up there. But if you own the vehicle out of state, even though it's not on this policy, stacking coverage will cover you for an injury in that car. So keep that in mind. Non-stacking will not. Non-stacking says you have to be injured in a vehicle that is on this Florida policy. So things like classic cars and motorcycles. Now, it stands to reason. If those things are listed on a Florida policy, then you're going to have coverage for it. But oftentimes, things like that are not covered on a Florida policy for one reason or another. Classic cars, motorcycles. If you opt for stacked uninsured motorist coverage, then whether those things are listed on the policy or not, you will receive the coverage benefit. Uncle Jeff, good morning. Nice to see you up in Buffalo. So, and Aunt Carol too. I see that. How are you? Let me see what else. So if you're injured in a car that you do not own, and this car is not available for your regular use, would you be covered on a stacking and non-stacking form? Yes, the answer is yes. This is a situation where it's kind of a one-time situation where you're borrowing somebody's car and you don't do it all the time. All right. Now, what happens if you don't own a vehicle, but you happen to use it all the time? For example, if you happen to use your mother's vehicle all the time and you're just not on her policy and everything else, well, a stacking version of coverage is going to cover you, even though you happen to use that vehicle regularly, whereas a non-stacking version of is not. So another difference to be aware of. I've already mentioned motorcycles, but if you are a motorcycle user, then you really, really, really be careful, because in Florida, there's a lot of ways that motorcycles are not covered. So make sure you're talking to your agent if you are a motorcycle operator and understand where you're covered and where you're not. And just protect yourself by getting the stacked coverage. That way you know for sure that you're going to be covered. All right, so that's what I had to say about the differences between stacking and non-stacking coverage. If anybody has any questions, of course, as I mentioned, you can call me after the fact on my cell phone. 833-VASTOLA is forwarded to my cell phone 24/7. That's 833-827-8652. You can call me with anything you want, just like you can here on the show. And if I'm able to answer your question, then I certainly will. If I can't, then I'll do the research. Keep in mind, if you call me on the cell phone and I think your issue is a radio show topic issue, I would say, would you please mind calling me on the radio? Because this would be great fodder for radio show conversation. Now, let's talk about bad faith claims. We're going to switch gears and talk about insurance companies and the fact that essentially they're obligated by statute to conduct business in good faith. And so good faith is a legal term which is, it's got a commonsensical definition, of course, but it essentially requires the insurance companies to adjust the claims honestly and fairly, and pay claims honestly and fairly and reasonably when they should. And so if the insurance companies don't conduct business in good faith, then they can be held to be in bad faith. And again, bad faith is a legal term, and it's a term that's regulated by statute 624.155 in the Florida statutes, of course. And it essentially opens up a different checkbook, so to speak, for the insurance company. So the way insurance claims typically work is that if there is a contract of insurance and if there is a covered claim, well, the insurance company knows that it's potentially on the hook to pay the claim up to the value of insurance that was contracted for by the parties. So automobile insurance, if you have a $100,000 bodily injury claim and you cause an accident and somebody's catastrophically injured, the insurance company knows it's likely going to have to pay the $100,000 for the tortfeasor, which is the party that caused the accident. That's, in its simplest form, the way insurance works. It works the same way in homeowners claims and any other type of casualty claim you can think of. So what happens, though, sometimes is that the insurance companies don't pay a claim that down the road it's determined they should have paid in good faith. But before you can start talking about bad faith claims, understand that there are some what we call conditions precedent to being able to pursue a bad faith claim. And one of those things is by filing a civil remedy notice. So if you're in a pre-suit posture with an insurance company, and I find myself in a pre-suit posture with insurance companies all the time because I'm a plaintiff's lawyer and I make claims against insurance companies. And oftentimes the insurance company is not wanting to pay the claim for one reason or another. Then if I feel as though the claim is potentially worth more than what the insurance company has in coverage, then, and for other reasons too, that doesn't have to be the only reason, then I will instruct my office to file a civil remedy notice. The civil remedy notice is a claimant notifying the Department of Insurance that this particular insurance company is acting in bad faith and explaining the reasons why. And you have to do that in certain situations in order to pursue a bad faith claim down the road. And if you don't do it, because it's a condition precedent, then your bad faith claim will either be thrown out or it won't ever get off the ground. You won't be able to find a lawyer to take your bad faith claim because you didn't do what you were supposed to do. And there's a case in the Florida Law Weekly, and I didn't tab it, so I may have a difficult time finding it, but it was one that I read this morning and I was really very surprised that it got thrown out. Okay, here it is. I found it. And I've got my contacts in, so I'm not going to be able to read the names very well, but it looks like the name is Junior Julian versus United Property. And I hate to say it, I'm going to have to get those cheaters. I turn 50 next month, and I'm going to have to get those cheaters on my eyes. But I was really kind of surprised because this was a decision where the appellate court said, yes, the plaintiff's lawyer seeking a bad faith claim did file a civil remedy notice, but what this lawyer did was list approximately, I think they said it was about 35 bullet-pointed bases as to why the insurance company was in bad faith. But closer examination of the civil remedy notice that was filed simply established that what the lawyer did was essentially copy and paste provisions of the statute and put them into the civil remedy notice, and didn't factually suggest how the insurance company was in bad faith. All he did, apparently, this lawyer, was cite reference to the policy. And the appellate court threw out the bad faith case, saying, yeah, you filed a civil remedy notice, and yes, it was extensive. You filed roughly 35 different so-called reasons as to how the insurance company was in bad faith, but you never told us once what did the insurance company do wrong. To me, that's kind of a harsh ruling, in my opinion, because obviously the lawyer put the effort in to send the civil remedy notice, and the lawyer even used the defense to say, hey, the Department of Insurance never told me that my notice was deficient. How was I supposed to know that my notice was deficient if they don't tell me? Well, the appellate court said, sorry, bud, that's not a legitimate basis to suggest that you should skate. And they threw the case out. They threw out the bad faith case because his civil remedy notice was not sufficient. So, it makes me nervous, but our civil remedy notices are typically pretty clear about what we think the insurance company is doing wrong. So I would like to think that ours would be sufficient. But anyway, in a bad faith claim, let me try to nutshell it, and so you can understand. If anybody has a question about this or anything else, you can call me at 877-850-8585. I'm talking about bad faith claims in summary fashion, believe me, because these are incredibly detailed types of lawsuits. But essentially, if let's just use a typical car accident. So you've got John Doe causing an accident, and let's say he injures. Oh my gosh, 30 seconds. I don't even have time to talk about this anymore. Listen, if you want to talk to me after the show, call me at 833-VASTOLA. That's 833-827-8652. If you want to find out more about me and my office and what we do, you can go to VastolaLegal.com. Thank you all for watching. Thank you for listening. And I hope everyone has a great week. God bless. Take care.